Thank you. And yes, delighted to be here at this launch event of what I think is such a powerful and important initiative. So contracts and innovation is the theme of our contribution and content. Contracts and innovation, not two words that many people actually combine. Yet contracts are, of course, a critical area of legal practice. They absorb a very substantial amount of time for in-house legal groups. On average, we believe around 50%. And of course, they represent a pretty fundamental stream of activity and income for law firms. And there is a degree to which contract law is, of course, an academic topic within law schools. So perhaps in many cases, leaving something to be desired when it comes to any concept or context of innovation. So that is changing, and we're working quite closely with a number of universities and business schools that really are focusing on innovation in law. And indeed, I have a secondary role, which is as a professor in the law school at the University of Leeds in the UK, where in fact I'm introducing a master's program, which is leading a collaborative activity between the law school and the business school. And that, of course, is a key point, that at the end of the day, contracts are ultimately business instruments. Every contract is designed and delivered with an economic purpose. And one of the challenges, I think, for the legal community as our world gets more complicated and as our contracts become more important instruments of business performance and of economic performance is, how do we adapt and adjust the role of legal? Do we indeed adapt and adjust? Is the legal community ready to innovate its thinking and its practices when it comes to modern day contracting? Now, why do I say it's changed? Well, clearly, contracts have gone through a number of upheavals over the last 20 or 30 years, not least, of course, the forces of globalization that often resulted in the need for multi-jurisdictional forms of agreement. But we have gone through, I think, a more fundamental change in many ways, of which COVID-19 is in many ways a catalyst, and the realization that we've moved progressively faster towards more and more of a services and solutions world, where the contracts that were designed at one point predominantly to support and enable the transfer of product and the shift of title have increasingly shifted to this world of services and solutions, of intangibles, where actually the contract may only be about the only tangible representation of what has been committed. So if we think about contracts in that context, I had an amusing conversation the other day with the head of marketing at a very large international corporation, who said to me, if contracts were a product, they would have been declared obsolete many years ago. And I think we do, as a community, desperately need to reflect upon the quality and the fitness for purpose of our product. Indeed, one of the challenges, I think, for lawyers is to make a decision of, are we going to block change, claiming ownership of contracts, even though we take no responsibility for the outcome that occurs from them, or are we going to step up and grasp the opportunity to take a much more integrated and integrational role for the business in really ensuring that the contracts we produce are fit for purpose, that they are in fact delivering positive results and outcomes for the business? And that, I think, is so important in this context of new technology. It gives us this opportunity. We can indeed just focus on technology that perhaps makes us more efficient, that cuts cycle times, that maybe to a degree empowers the business with self-service technologies so that we have automated contract production, that we move from templates to clause libraries. These are all exciting developments, but ultimately they are just about business efficiency. Our opportunity, and I think so much of what we need to debate and discuss, is how are we going to deploy things and lead in areas like artificial intelligence and machine learning, the adoption of blockchain to create business platforms for contracting. COVID-19 has clearly demonstrated the severity of many of the friction points associated with the contracting process. It also revealed the massive inadequacies of current data flows, where contract-related information in the average corporation is spread across 24 different applications, none of which talk to each other. Contract data sits in pools and puddles around the business with no connectivity. COVID-19 showed the severity of that, the lack of transparency, the lack of control, the lack of good business information. Do we want to grasp that opportunity? Do we want to be the catalysts for change? There is so much exciting work going on, and certainly within this module, we'll be trying to inspire, excite, and inform. Our ability to do that is driven by the fact that we are a 75,000 member global association. We have around 25,000 different organizations from across every industry involved in the association, and much of our work is around driving a strong research agenda in commercial and contracting, reaching out to legal communities, contract management, commercial managers, procurement organizations, to assemble practical insight, knowledge, and data around what is going on and what is needed. We combine with that strong links out to academia, a substantial number of the law schools around the world, and we embrace both public and private sector, both of which, in fact, are today on an urgent innovation agenda. So we are excited to be able to bring such insights to this community, and absolutely look forward to working with those who choose to enroll in the programs, and of course, connecting with the illustrious group that Jacques has brought together to deliver this exciting portfolio of programs. With that, Jacques, over to you.
Thanks, Tim. It was great. There's a question, so it's directed to you, so let's deal with that now. What role do you think technology can play in the future of contract making? How is that relevant for lawyers, and how will the course help us understand this better and get more experience?
Yes, there's a lot tied into that question. Clearly, there are varying levels of automation and digitization that are occurring that absolutely affect contracts. So I think, as I alluded to, we have a choice. Do we just look at automation as a way to increase efficiency? So, for example, through things like automated playbooks, we can shift the model for contracting. You may have heard, and some of you may have participated this morning, one of my colleagues, Stefano Passera, talked about contract visualization and contract design. So we can, of course, redesign contracts to make them more readily understandable, more usable for the business. All of those are very worthy initiatives. At the other end of the spectrum, however, we can start using technology to really start searching into large-scale contract portfolios. we can start to extract from that information, and people are starting to do this, much more predictive risk analytics, for example. What are the characteristics of behavior of counterparties that begin to indicate risk? We're working with a legally led team that's looking at precisely that sort of predictive analysis of risk. We're looking and working with others who are saying, actually, how can we begin to analyze the combination of which terms and conditions tend to be associated either with heightened levels of success or heightened levels of failure. So we begin to look at behavioral impact of terms and conditions, an area of psychology and thinking that has just not been embedded in the law faculties of the past. So I hope that gives a few sort of indications and sort of, I hope, for many exciting thoughts about what we can start building into this program of innovation.